informs information to help them prevent themselves from sexually transmitted diseases, including HIV. My Lord, paragraph 14 at page 7 of the record of memorandum, it's clearly stated that girls were lured into sexuality without use of any protective means, whereby boys told them that in any case, if they used a condom, their vaginas would fall out. And if they dared to take a pill, their nipples would grow hair. This is a clear indication that these young girls do not have information, and that is why they could not take informed decisions. My Lord, the result of this is seen still under paragraph 14, page 7 of the record of memorandum, where these girls got pregnant and they were infected with HIV. My Lord, it is also important for us to note on the record of memorandum at paragraph 13 that one of the girls who got pregnant and was trying to procure an abortion lost her life on the arrival to the hospital. This shows that indeed there is need to provide access to information and, most importantly, sexuality education. The applicant mentioned a blanket of articles where the right of access to information is provided. As the respondents would do agree that those articles exist both in the Constitution and other international human rights instruments. However, my Lord, it is the respondent's submission that mere adoption of these legislations cannot guarantee the protection of socio-economic rights. That further measures should be taken. The practicability of these measures should also be shown. And this is according to the Limburg Principles on the implementation of International Covenant on Economic, Social, and Cultural Rights. Therefore, the fact that they have they have a blanket of articles both in the Constitution and other international human rights instruments does not guarantee the access to information and, most importantly, appropriate sexuality education. It is therefore the respondent's submission that the state indeed failed, as already held by the Land Justice in the High Court, to provide access to information through appropriate sexuality education. Therefore, respondent's submission that this court also upholds the decision of the Land Justice in the High Court that indeed the state failed to provide this kind of information, even when it is obliged to do so. With your permission, my Lord, I would like to proceed and respond to the second ground of appeal. Much obliged, my Lord. The second ground of appeal is on the failure of the state to pass a policy on sexuality and reproductive health to protect vulnerable groups of people from harmful cultural myths and practices as being a violation of their right to education, health, and life. My Lord, it's the respondent's submission that indeed the state failed to pass a policy on reproductive health rights. What the state did was only to draft a bill, which bill, when was taken to Parliament, was boycotted, and no further discussions have been held on this bill. That is on paragraph 4 of the record of memorandum. And it's the respondent's submission that the state, having failed to pass a policy on sexuality and reproductive health rights, it failed to protect the young girls from harmful cultural myths. My Lord, the question is, what are harmful cultural myths? Under Article 5 of the Maputo Protocol, which the Republic of Insiche is a member, states are obliged to take all necessary and legislative measures to eliminate all harmful practices which negatively affect human rights of women. The definition of harmful practices is in General Comment Number 2 of the African Commission on paragraph 62, where it defined harmful practices to be behaviors, attitudes, and practices which negatively affect the fundamental rights of women and girls, including the right to life, dignity, education, and personal or physical integrity. My Lord, I would like you to turn with me to paragraph 6, to page 6 at paragraph 5 of the record of, and therefore fulfills the definition of what are harmful practices as I've already stated. And this being discriminative, it violates also Article 21. Even when the applicant asserts that if another applicant asserts that some of the rights can be limited and made reference to Article 41, Clause 1 of the Constitution, where she actually stated that, where she stated the conditions that can actually amount to a general limitation of fundamental and human rights. Clause 2 of Article 43 mentions one of them as being public interest under this democratic society. My Lord, the applicant did not tell us which democratic society does not uphold the right of access to information. Which democratic society does not observe the reproductive sexual health rights? That now it is within that interest that this information should be upheld. And even then, Article 3 of the Covenant on the Rights of Children states that whenas all measures are taken, it must be in the best interest of the child. The question is, have the appellants failed to pass a policy on sexual reproductive health rights in the best interest of the child? Does the abortion, the loss of life, the dropping out of school amount to the best interest of these children? Whereby if we do not pass a policy on the same, we would have actually violated these rights. I would like to persuade this court with the case of Sehad versus Attorney General and Life Network, miscellaneous cause number 309 of 2016, whereby the court emphasized that delay to issue a policy on comprehensive sexuality education violated the rights to education, health, and life, since the young people are vulnerable to abusive relationships and health-associated risks like pregnancies, my Lord, the exposure to sexuality transmitted diseases, including HIV/AIDS, which in the present case, my Lord, has already happened, and we have already started feeling the impact of the delay of the state to pass a policy on sexuality education. My Lord, it's the respondent's submission that indeed we need to uphold the decision of the land justice in the High Court. Because indeed there is a delay, and even which delay is not justified, because the Congress has already ceased to discuss the bill and has already been boycotted. And it's therefore the respondent's submission that we uphold the decision of the High Court, and also find that indeed the state failed to provide access to information and also failed to pass a policy on sexual reproductive health rights, which has now exposed these young children to harmful cultural myths. Even when people have a right to culture, Article 2, Clause 2 of the Constitution says, when any custom or norm is inconsistent with the Constitution, it shall be rendered null and void. The discrimination of these girls from state with the Constitution, which under Article 21, Clause 1 says, everyone is equal before the law. Therefore, the respondent's submission that indeed we uphold the decision of the High Court and find that the land justice did not err in fact and law by holding that indeed the state failed to provide access to information. This court is the guardian of human rights. The decision should be in the best interest of these children who need.
May it please this honorable court, my name is Nasija Gloria, as earlier in submissions made by the appellants under ground 3 and ground 4. The appellants submitted that they aimed at protecting morality and relied on the principle of best interest. And this principle of best interest is enshrined under Article 3 of the Convention on the Rights of the Child. And regarding on the best interest of the child, general comment number 15 on the full enjoyment of the rights of the child provided therein that the right to education includes the right to education on sexuality, which the appellants have neglected, claiming that they are trying to protect culture. And we do acknowledge that the right to protect culture, the state is obligated under National Objective and Directive Principles of State Policy 24 to promote and preserve the rights of culture. However, while doing both, the state is also obligated to protect other rights. This includes the right to information, the right to education, and also the right to health. And the appellants cannot dwell only protecting on one right while ignoring the other rights. And furthermore, under general comment number 22, paragraph 47, it was stated therein that the obligation that states are obligated to incorporate unbiased, scientifically accurate, comprehensive education for all persons on sexual and reproductive health, and which was violated in this instant case. If I may refer this Honorable Court to the record memorandum under paragraph 4, it is stated there, paragraph 8, I beg to retract, paragraph 8, the students in that state were not even able to answer basic questions on anatomy. And this shows how the failure to access sexuality education affected them. And furthermore, the failure to access this information is further reflected in under paragraph 13, where my co-counsel has also earlier on relied, and also paragraph 15 and 16 of the facts. And under these paragraphs, under paragraph 16 in particular, the girl had used charcoal in order to conduct an abortion, and she used unsafe methods of abortion. However, also, although the state of Nsiki made a reservation on Article 14, Clause 2, Paragraph C of the Malabo Protocol, this state also has national legislations that legalize abortion. And under Article 22, Clause 2 of the Constitution of the Federal Republic of Nsiki, it provides that no person shall deprive the other person, no person shall deprive the life of the unborn child unless authorized by law. However, the national directive policy goes ahead to explain on this. Under what circumstances would a person be permitted to conduct these abortions? And one is in cases of rape, cases of incest, cases of where a parent has HIV or fetal anomaly. And as we can see, that in the instant case, there were cases of rape, as these girls had been raped, as reflected under paragraph 15, when Ms. Awilo went to lodge the complaint, and these girls had already washed their clothes and they had already showered, and there was lack of evidence. It is in that regard that they had been raped, and due to lack of sexuality education, because they would have reported such. They are mainly aimed at protecting morality. It is not in the best interest of the child, as it is also an obligation of the state to provide access to information, of which these provisions the appellants have cited. That is Article 41 of the Constitution, Clause 1. And furthermore, in the case of RR versus Poland, that was before the European Court of Human Rights to hold decisions relating to health matters. However, in this instant case, as these children had no access to health, to sexuality education, they weren't able to make informed decisions about themselves, as even when they were told about the myth that if they have sex using condoms, then they will lose their virginity. So had they had access to this sexuality education, then this wouldn't have resulted. In conclusion, that the appellants to health that are all provided for within of the failure of the state to investigate, the appellants submitted that they are still investigating. However, in the case of EL versus Nigeria, that was before the ECOWAS and also the UN Committee on the duty to investigate, prosecute, and punish, it was noted therein that these investigations ought to be prompt and impartial. However, in this instant case, these investigations have not been conducted promptly. And also, this state has its obligation to punish and prosecute the violators of violence against women under Article 4, Clause 2, Paragraph E of the Maputo Protocol, which the state of Nsiki didn't take into consideration. And also, the appellants cited a case that was on murder and stated that in that case they took time to investigate because they wanted to get before arresting, they wanted to get enough evidence. However, in the case of Uganda versus Kagongo, that was before the High Court of Uganda, if I may persuade this honorable court, it was stated therein that in matters to deal with rape. A testimony by the victim is sufficient. And in this instant case, under paragraph 16, it is shown that although these investigations were commenced, and even when the perpetrators of this sexual violence were known, they were not arrested. And in that regard, we respond and submit that they failed on their duty to investigate, and they are relying on a case on murder, and these two offenses have different ingredients that need to be fulfilled. And structural interdict is a directive that is given to control. For example, in the case of Sehad, the lady had directed the police to conduct the investigations and find the other missing child. So the court has the power to direct through structural interdict. And also, the appellants submitted that the state is a developing state and it's unable to fulfill these rights. And as my co-counsel, as earlier had just recovered from COVID, and it had financial constraints. However, under Article 2, Clause 1 of the International Covenant on Economic, Social and Cultural Rights, it provides that although the state is trying to fulfill the economic, social and cultural rights using the available resources, they also ought to seek international aid or international support. And in the instant case, there is no evidence that in order to fulfill this economic, social and cultural rights, the appellant sought international aid. And this is also restated in the general comment number 22 that states ought to seek international aid in order to fulfill their economic, social and cultural rights. And also, in response to the appellant's submissions made under the last sub-issue on the failure of the state to provide healthcare services, as my co-counsel has also earlier on discussed on these obligations under paragraph 13, a girl lost her life due to lack of medical equipment that would be used to prevent further harm. And under general comment number 14, paragraph 12.1, it is provided therein that in order for the right of health to be fully realized, there needs to be accessibility, and in this instant case, the distance of the hospital, this includes physical accessibility, the distance of the hospital from where this girl had been admitted was 12 kilometers, and this distance was really unreasonable. That eventually resulted to the death of this girl. And also the state still failed on its right to provide healthcare services and also educate. This is provided for the minimum core obligations for a state to fulfill when they state that they don't have the available resources to fulfill the economic, social and cultural rights. In the African Commission on Economics, in the African Commission on the implementation of economic, social and cultural rights, one of the minimum core obligations is this state, the state parties have to carry out prevention, and they also have to educate. However, in this instant case, there is no evidence that the appellants, in order to fulfill their obligations, carried out an education on the effects that have been faced by the community, as we can see that in the celebration of the Grab the Meat, some of these girls were raped, and if this state had carried out its obligation to teach these girls on sexuality education, then these cases wouldn't have resulted. In conclusion, we pray that this honorable court upholds the decision of the High Court, and in upholding, it declares that one, the Federal Republic of Nseke violated its rights in order to provide and ensure essential training and information to the girls, and also it violated its rights in order to carry out the investigation and prosecute the violators on sexual and reproductive health, and it also failed to prosecute these perpetrators on the sexual offenses, and further, it also failed to provide health care services to the victims. and we pray that this honorable court, through structural interdicts, directs the appellant to pass a policy on sexual and reproductive health rights. And we pray that this honorable court awards costs to the parties, and also rehabilitation of the victims, as we can see under paragraph 16, that the two albino girls have been so withdrawn and they have been going through psychiatric evaluation. However, this has been reported to the police, but there has been no intervention. And the state has the obligation to protect, but it failed on its obligation to protect as provided for under Article 4, Clause 2, Paragraph F of the Maputo Protocol. And we also seek that, relying on the Human Rights Enforcement Act, the appellant gives a public apology to the citizens so that they can restore their trust in the state, that they are willing to uphold the right to information, the right to access, the right to education, and
who will give the apology?
The state.
Who? Who is the state in this case?
As we can see, that the Attorney General is representing the state on its matters. I so beg to submit.
Okay, thank you, co-counsel, for the respondent. We have a few questions for you. Counsel Sharif, Sandy.
Much obliged, my lord. It's the duty of the First Appellate Court to revise and reevaluate, endorse before that court and reach its own conclusion, taking into account that the Appellate Court did not have an opportunity to hear and see the witness testimony, and this was provided for in the case of Birungi versus Uganda, and also under Rule 30, 1A of the Court of Appeal rules.
Okay, let's hear from the lady justices.
So, Counsel Sharif, in your second legal argument, you noted that girls who are not virgins do not participate. Can you elaborate on how it's barred from practicing in a cultural event? How is that harmful to them?
Much obliged, my lord. Article 5 of the Maputo Protocol, my lord, states that obliges the states to take all necessary and legislative measures to eliminate harmful practices which negatively affect human rights of women. Harmful practices, my lord, refer to behaviors, attitudes, and practices which negatively affect the fundamental rights of women, and among them is the dignity, education, and physical integrity. And that is according to the African Commission General Comment number 2 at paragraph 62. In regard to the case at hand, indeed the discrimination of girls who are not virgins from taking part in the Grab Miss Mate Festival is a harmful practice because it deprives them of their dignity as girls and also of their physical integrity. It would have showed clearly that they're not virgins, and of which not being a virgin is not a crime, my lord.
Thank you, Counsel.
Much obliged, my lord.
Counsel, Miss Gloria Nasije, I want you to differentiate between costs and damages. You concluded by asking court to award costs to the parties because the albinos were affected. So just distinguish for us the costs and damages and when the court should award.
Okay. Much obliged. I'll start with the costs. In the case of Chizeria versus Attorney General Constitutional Appeal number 1 of the successful litigant, the expenses incurred during the litigation. And it is also further provided under Section 27 of the Civil Procedure Act. And Honorable Justice Kakuru noted that costs should not be awarded by way of penalizing them so that they should not get scared from coming to court. So our costs are not a penalty, but they are only an indemnity to compensate.
What is the difference between costs and damages? Because when you came off requesting for costs, and you're also aware that costs can follow the event, okay? Not so? So, you're asking for costs, but what is the reasoning behind you asking for costs to be awarded to the affected parties? That's why I asked you to differentiate between costs and damages.
Much obliged. In regards with the damages, these are used, it's more of a restitution remedy that is used to restitute the party to the former position they were in. Yes, much obliged.
Thank you, Counsel. Counsel Gloria, just before you sit. In whose favor are the damages sought?
In the favor of the respondent.
All of them?
In particular, with that, these victims of the sexual and reproductive health.
Which kind of damages are you seeking?
General damages.
Thank you. Counsel Sharif. My learned sister did ask the same question earlier. However, I also had a similar question that is hinged to the one she asked previously. If you do consider that the Grab Meat Festival is a harmful practice, a festival in which virgin girls are the ones who attend such a ceremony, how would you consider that? How would you consider that being a harmful practice in light of the fact that the respondent submitted that it is limiting to regulate such a cultural custom celebration in view of the fact that it is protecting the right to practice a culture?
Much obliged, my lord. The Republic...
Just a second. Yes, and also, as you address me on that question, bear in mind that these girls were actually lured. Not because of the festival, but they were lured by the boys.
Much obliged, my lord. I request to start with the second question. My lord, in my submission, I stated that indeed it is true, we agree with the applicants that they have a duty to protect the rights of people, and among them is a right to culture. However, my lord, we stated Article 2, Clause 2 of the Constitution, that when any custom is inconsistent with the Constitution, it shall be rendered null and void. When celebrating the Grab Meat Festival, among the practices is that girls who are not virgins cannot take part. And this practice now turns out to be a harmful practice, like I'd already defined earlier, because it intimidates the integrity of these girls. And this makes this practice under this culture to be inconsistent with the Constitution, which provides for the right of equality under Article 21, Clause 1, my lord. Have I answered your question, my lord? Much obliged, my lord. And that is why we say the right to culture can still be limited if those customs are inconsistent with the Constitution, and we have already elaborated on those customs. I beg to submit.
Okay, thank you so much, both parties. This court is going to be stood over for 5 to 7 minutes to enable the bench to deliberate on your submissions and then deliver its ruling in terms of scores. So I accordingly stand over this court for now. Okay. How does it feel? Huh? Hot. Eh? Reminds me of doing an interview and then you hear the results are out. Then like, send it to me on my WhatsApp. Then as you're opening, it's not opening. As you're opening, it's not yet you have data. Eh? Yeah, it's good to have a positive competition, even amongst us. If we are going for interviews and I have my sisters here, it's okay to go and compete, read and compete. You know, it's healthy. As long as it's healthy, it's positive, and that's what life is about. You should always look at it from the positive side, you know. Yeah, first of all, I want to congratulate both of you, both teams. Because you're aware some teams didn't make it up to this level. So it's a plus for you. Whether you make it to the finals, it's already a plus, you know. It's already a plus. So for me, it's a good thing, irrespective of the results from the judges. I appreciate you and I encourage you to keep it up. Because the fact that you are participating in MOOT, it shows that you are, by the way, as a lawyer, first thing that you should get in your mind is that you are above average. As when you mention I'm a lawyer, just know you are above average. If they are looking at 50, it means you're at 51. Others are below 50. But for us, we are above average. Pick. Not everyone can be confident. You're confident. And that is how a lawyer should be. When you speak, people should know that this guy is a lawyer. This lady is a lawyer. You speak with confidence, even when you are not sure. Never let. That's why in one of the observations we've noted is that one of the team did not appreciate the facts, and that is very dangerous. Never let your client know the facts better than you. You can imagine you were not there when your client was entering into a contract with the employer. You were not party to that contract. That contract has been breached by the employer, but you are expected to know those facts much better than the employer, much better than the employee. much better than even the presiding judicial officer. That is what will make you a lawyer. Never let your client know. Imagine you standing up and you're making a submission, and then your client says, no, it wasn't like that. That's a very, very big embarrassment. So, appellants, you didn't appreciate the facts. You didn't appreciate the facts. I could hear it in your submissions. It was after lunch, but I concentrated. But I could feel something is missing in the appreciation of the facts, in the applicability of the law. I could feel it that it was missing. It was missing. And yet, trial is about evidence. It's about knowing the facts in this case, in the instant case. It's about knowing what the problem was, what ought to have been done, what are the minimum standards, what standards have been applied, what standards ought to be applied. It's about the facts. The law is secondary. It's just supporting the facts, legitimizing the facts. But you're supposed to appreciate the facts. That's why these some litigants go and argue their cases. They are not lawyers. Of course, forget Mavidis. That one is not a... We are talking about sober litigants who can appear and argue their cases. How do they win? Facts. You know, someone knows their case very well. On this day, we entered into this agreement. These were the terms. These were the duties. These were the rights. These are the rights that have been infringed on. Like someone knows their facts. So, if you don't make it to the next stage, because I don't know what will happen, what the results will be in the other side, but if you don't make it and you happen to participate next time, ensure that you master your facts very, very well. Then also, we noticed that you were still locked up in the trial court, and yet we introduced ourselves as justices. You were now appearing before a court of appeal. That would mean you can't start citing high court decisions, because you're appearing in a court of appeal. You know the hierarchy. When you're appearing in the Supreme Court, you quote decisions of the Supreme Court, which they agree or even move away from their previous what? Decisions. When you're in Court of Appeal, you quote decisions of the Supreme Court. When you're in the High Court, you quote decisions of the Court of Appeal. Or you could quote the ones of the High Court. Although nowadays you find one person is saying this, another person is saying this, so it's better you cite a decision of a higher court to be on the safer side. But all of you were quoting for us high court decisions. And now tomorrow, if you appear and you ever quote justices, they are real justices. For us, we can say it's okay, it's easy. But now when you appear before them, that is an offense. They will not take it lightly. They will call all those coordinators who are seated behind you and first mentor them, because they expect you to have gone through introduction to law in your first year. They expect you to have read Chidu Makuya, Introduction to Law. They expect you to have read Graville Williams. Am I speaking science? Yes, I read these things. That's why I'm seated this side and you're seated the other side. Know the law. Know where the law is. As a lawyer, reading the law is our Bible. If you're a Christian like me, I cannot spend a day without reading my Bible, because I know once I don't read my Bible, I will miss something. So it's the same thing with law. You're supposed to know and read and read. So tomorrow, please ensure that you don't quote decisions of the lower courts, not even Court of Appeal, because you will be appearing before the Supreme Court. So I also leave my my sisters to say something, and then I read out the overall scores.
Thank you, my brother. Let me just start by commending you on your smartness. You look presentable. The ladies are smart. The other team is also smart. Thank you. Just to add on what my brother here said, you're citing High Court decisions, but to make it even worse, you don't cite the full authority. It is just Attorney General versus this. High Court, what number was it? Which year was it decided? You might end up citing a case that was even overruled on appeal. So that's why we're saying when you appear before this is justices of appeal, please, it's better you cite Supreme Court, because there I'm bound. I'll have to follow what the court said. The other thing is, when you present, I just urge you to be dynamic and creative. Don't lock yourself so much into what Sehad has given us this. Just be more creative. Look at other things out there. Don't just look Sehud versus this. Just try to be more creative. It tends to get boring. And we've had this since morning, so it's just rotating around. You look for something that is unique, and you don't find it. So if you're appearing tomorrow, any of you, those are, like they told you, they're real justices. Don't bore them. Lastly, yeah, you're citing cases, you're applying your laws. How do you bring it within the facts of this case? Most of you are just saying, like in this case, it was decided this. Like in this case, bring in the facts. Connect in that case, this is what the court decided. Relate it to the facts at hand, then bring in your conclusion. But don't just, it's like you're just reading essays, reading for us essays. Just, sometimes you can even be brief. You don't have to state all those facts, but we've got the point. So just bring in the facts, apply the law to the facts, conclude. Yeah, otherwise you all did well, and yeah, thank you.
Okay, we shall also we're also going to listen.
Thank you very much, my learned brother. Congratulations and well done, counsel, who appeared before us today. Level, art of advocacy is very important for all of us. Go back and practice. Once you know that your team is going on for the next round, go back and practice your oral speeches or your oral statements that you're going to be giving before the Supreme Court. Because you'll find a justice who will tell you, no, we already have the record. We know what the facts are about. We know what is in paragraph 1, 2, 3, 4, and 5. So telling them, please refer to paragraph 5, they will tell you we know. And once they tell you we know, then you're going to start looking like, okay, so you know what was my next point on the script? You start referring to your script. So go back and practice your oral statement. In practicing your oral statement, you're looking out for cases that you're going to rely on to persuade the bench. That is very, very important. Don't just cite the case. In this case, it was held, blah, 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 blah. Go ahead and say, in this case, the facts are similar to the matter that is before you, learned justices. in that case. They held A, B, C, and D. We pray you be bound by that decision to follow the same findings and conclusions made in that case. I also seem to find out that you do not know about structural interdicts. Do go ahead and do some more reading about them. You'll find that they are very good, especially during constitutional issues or matters. And one last thing I would like to say is that you surely did put in the effort, and we appreciate you all.
Okay, yeah. Now this is the time. I will read the overall individual performance from each justice. Start with Counsel Sandy. Let me first read this, then I'll come to you. I'll start with Counsel Monica. Counsel Monica, one justice gave you 74, another gave you 71, another gave you 90, no? Appearance. Another gave you 86. Then Counsel Angel, one justice gave you 65, another one gave you 70, another one gave you 71. Counsel Sandy, one justice gave you 87, another one gave you 83, another one gave you 93. Counsel Gloria, one justice gave you 80, 91. Now, overall performance, average performance for both teams. Appearance, one judge gave you 69.5, another gave you 70.5, another gave you 78.5. Respondents, team average 83.5, 77, and 92. Now, overall average performance from the three justices: appellants 72, respondents 84. Congratulations to both teams. Appellants, respondents.
Good evening. Welcome back from the semi-final rounds. And congratulations to all those that made it through. I'd like to confirm if the teams that were in Rizzi Hall are back, CLMA and CLMD. Are they back? Yeah, kindly ask them to come back. We've literally come to almost the end of the day today. But I would like to encourage every participating student, please do not wait to go, because we have to handle some logistical issues with you today. So if you're not around, you might miss out on that. So kindly be patient, whether or not you're participating right now. Please stay around, because we need you available. So as the other teams come back, the person compiling the marks, I know they've already announced to some of you, and you know what your fate is, but the person compiling the marks is going to come and reconfirm that, so that we can get to know of the 4 teams, which team won in semi-final round 1 and which team won in semi-final round 2. Then as soon as that is done, before we get teams that have gone through or would have gone through, to step back and choose their side for tomorrow, whether you're going to be appellants in the final round or respondents in the final round. Then as soon as that is done, we are going to go into the final step for today, which is awarding. So today we are going to award our judges, our MOOT judges for the day, and we are going to award the 2 teams that emerged with the best and second best memorials. We are awarding according to the marks. I think I already emphasized this earlier, but I'm just going to re-emphasize it. How we came up with the best and with the 2 best teams for memorials is from all the written today, the different rounds today, and each judge awarded each team. So we got the marks for each of the judges, and we did an average to know what each team got all together, and that is what formed the average there. Yeah, so the 2 teams, the team with the best memorial and the second best memorial, are going to be awarded today, and then we shall receive the rest of our awards as students, as coordinators, tomorrow. Yeah, and something I wanted to emphasize lastly is, in case you want to know your marks, if any team wants to know the full marks that they got in their memorials, please feel free to contact us. We have the scores somewhere, and we can show you. If you want to know how each judge ranked you, or if you want to know, not even judge, but if you want to know the scores that you got, yeah, in your memorials, please feel free to come. We can show you the full marks that you got, because we have the records with us. Yeah. So team CLMA and CLMD, are you back? Team CLMA, where are you? And team CLMD? Team CLMI, where are you? And CLME, where are you? This team, eh? Okay. So let me invite Frank to declare for us the 2 top teams. Like I mentioned again, this is it was a knockout round. So it doesn't matter if the 2 teams here or the 2 teams there got higher marks than any other team. It was a knockout. So the best team over the other is the one that proceeded to the final round. And we are going to get to know which 2 teams those are from Frank, and then we can go into the final stage. Thank you. Yeah, so as we finalize, I would like to get some feedback from the teams, all the participating teams. If you can give us some feedback, how you found the rounds, how the day went for you, were you comfortable, like what transpired? Yeah, we need to get, so if you have anything burning, feel free to share. Where is the second microphone? Here. Yeah, give us some feedback, because we like getting feedback so that we can make it better every other year. But also we are going to give you evaluation forms, yeah? We have evaluation forms for you as students and coordinators, and also evaluation forms for our judges, because we want to get feedback from you, what went well, what didn't go well, and we can be able to improve the following year. So over to you.
It's a pleasure for us as Uganda Pentecostal University to be here once again. And like I MOOT competition, I am in third year, but my colleagues have always been here, like Jason Muhindo Mutunzi, and he told me, when you're going there, make sure you know your facts. I will first note that those facts that you gave us, they have that funny name, Ekinihiro Rujavura Ntongo. It is something much as I am Mtoro, it gave me hard time to comprehend. I don't know, because I asked my coordinator, how does SEAD come up with these funny things, really? Last year I saw something like the federal was Oyanda. This year it is in Siche. Wow, I said, these guys, I admire you. I don't know how you do this thing. Whatever magic you have, there must be someone behind this thing who imagines these names. And I told my coordinator, the person who comes up with these names must have done literature, and he knows what it means to come up with a hypothetical case that is imaginary. You know, you read the facts of the case. There is, in literature we had what they call, we could of course comment on the style of the poem, then those imaginary tools. Then when I read the SEAD hypothetical problem question, the only thing I could see is the beautiful girls that are virgin, walking with the local, carrying the local brew. I said, really, I must participate in this MOOT competition. The mere fact that someone came up with the fact that the girls who are brown in nature, they're carrying they're carrying calabashes of local brew. You know, then there is that element of how it is done. And the only thing I would like to comment is that whenever you want us, we are ready. I've realized that SEAD has something that it is fighting for. These rights that we are advocating for, they are rights that need to be acknowledged. And I would like to thank and applaud the organizers. Please keep the spirit going. We shall always be there. Whether you want us till midnight, we are here. Why don't we have the Supreme Court justices convene? We do this thing. But anyway, since it is prepared for tomorrow, I cannot wait. I want to see still. I want to argue. See the beautiful girls walking down the Mwizi Mountains carrying calabashes of local blue. Thank you so much, Madam Dafa. I appreciate whatever you've been doing for us in the group. You've always clarified this, clarified that. Thank you so much. Thank you for granting us this opportunity. We wouldn't find it anywhere. One thing I've learned here is that you people are professional. We've been to other MOOTs, but, you know, there is a difference. There is a fundamental difference. Thank you so much, and uphold the same spirit. My name is Tumwesige J.
Thank you, Jeff, for the feedback. And I know most of you already know so much about SEAD, right? You guys know that amidst the facts that you find in those problem questions, behind it are the realities of the clients that you work with. Behind it are the realities of the people that actually come to us to seek or to try and access justice. Behind it is a girl who has gone through that particular scenario. So the facts that we give you, most of them are about realities of the people that we deal with in our everyday to-day life, of what can we do better as SEAD if you're to also go to court and face that judge tomorrow. What things can we pick through from that? So even as you're presenting, it could seem like you're competing, but for us, we are picking lessons. We're asking ourselves, if this team raised this issue, maybe even us, we should have looked at that issue in that way. So for us now, you know, you're still in law school. Some of us left law school as that law student right now, you know. So whereas for you, it's more about you want to compete and win. For us, it's about what do we pick from those students? What's that one thing that if I went to court tomorrow, I can maybe pick from that particular person, benefiting, not benefiting, but trying to make ourselves better from the knowledge that you share with the judges here. So thank you very much for that. Any other feedback? Frank, are you ready? Okay.
So good evening, everyone. So the long-awaited time is here. I hope everyone is well and comfortable, right? Yes, thank you so much. So I've been enjoying the English from behind there, but also trying to translate it into numbers, or the number equivalence, or the percentage equivalence of the English and the law. So we had the following results from 4 teams. I'm going to read the results per team, and then I also read the results per individual. So we had Team D, Team A, Team I, and Team E competing. And I'm not going to read them in any order. So Team D was represented by Council Chigozi Herbert, who scored an average of 75.3. The same team was also represented by Council Tumwesije Jai, who scored an average of 82.3, and this gave an average of 78.8 for the entire team. Then we also had Council Lydia, who scored, Council Moses scored an average of 79.7, while Council Lydia scored an average of 76.0, giving the team an average of 77.8. Then we also had Team I, which was represented by 2 people, Council Sunday and Council Gloria. And Council Sunday scored an average of 87.7%, while Council Gloria gave the team an average of 80.7%. And then lastly, we had Team E, which was represented by Council Monica and Angel. Council Monica scored an average of 77.0, while Council Angel scored an average of 68.7. So from the scores, the average score for the teams, Team D came in position number 2. Team D came in position number 2 with an average of 78.8. Team A came in position number 3 with an average of 77.8. Team I came in position number 1 with an average of 84.2. And team E came in position number 4 with an average of 72.8. So if you want to see the further details of your marks, I'm right behind in that corner. Thank you so much.
For tomorrow's final. Who are the winning teams? The team coordinators, please come. CLM? 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 Okay. So we have the teams for the finals. Pick up. So, tomorrow for the final round, CLMI are the appellants, right? And CLMD are the respondents. So we are going to request that two teams, when everything is done, kindly stay behind briefly for a brief meeting with the SEHAD team. It's about tomorrow and the grounds of appeal. Yeah. Congratulations to you all. So at this juncture, this is the final part. I promise I'm not going to hold you any longer. I'm going to invite our Deputy Executive Director Programs, Ms. Nachibuka Nuru, to come and preside over the award ceremony. For clarity, again, the two teams that we are standing here, if I'm not mistaken, had the best and second best memorial, right? Right? From what I see there, Team CLMI had the best memorial. They had 74 points. Were the second, and they had 71.4. So, we are going into the award process to award our judges, but also to award those two teams with their reward for having the best and second best memorial. So, Ms. Nachibuka, you're very welcome. Again, I encourage the rest of the teams, please don't feel bad. I don't know if you're proud of yourselves, but we are proud of you. Because by the time you came here and had to argue your case before that single judge or before that panel of 3 judges, it takes confidence. And for us, we are very proud of you. So don't feel bad about anything. I hope you've learned a thing or two from the judges' comments and you can be able to go back and use it to make yourselves better. No, you're welcome.
Thank you so much, Tim, and thank you, Esther. But the room is so dull. We traveled all the distances, all the way from where we've been to come and even present. You don't have to be dull. This is not the end of life. Life continues. Please don't get disappointed. Be proud of yourself that you've actually taken part in this particular MOOT. Many wanted to be here, but they're not here. So I'll request the teams that while we are awarding today, please be notified that there are other awards for tomorrow. So when you walk away because you've been knocked out, it means that we shall not be able to find you wherever you are to give you an award, because they're beyond this. The ones that have been part of the MOOT know that on the last day we have several other awards, even for the teams that have been knocked out, because you might have been knocked out, but you're the best oralist. So if you're not here, then you'll not know what the award looks like for you. So get in. It's also an issue of learning. I was disappointed at a moment when the room was almost empty. I'm like, where are these universities? Because you see, you might have made a mistake somewhere, and the judge gave you feedback, and another team is correcting that mistake. So how will you learn if you just walk away? You get? So I really want to appreciate you. Be happy. I earlier said we never got these opportunities. Never. You have sharpened your skill of standing before an audience. You've been before the judges today. Tomorrow you're going to be like me, and you have to speak to people and you have to look at them straight in the eyes. That's a skill you've picked and you don't pick anywhere. So appreciate yourselves for doing well, and appreciate yourselves that you've been able to read and understand and research and put sense into what was provided to you. Are we together? So I really want to take the opportunity first to thank you all for walking this journey. I thanked the students, I thanked the judges. I didn't thank the MOOT coordinators and our supervisors, but I've noticed that in this room, there are actually some of our supervisors who are our lecturers with us, who give us the courage and the support. So I really want to take the opportunity to also appreciate you for working this journey with the students, while others don't have them here. So perhaps please encourage other universities that you know it is beyond what you study at school. It is how you actually walk a journey with a particular coordinator, who are some of them are our lecturers. I really want to appreciate you. So my role is to award. I don't know who I start with. I don't even know who to award, but the team has organized. Okay. So I'm told that we had lovely judges today who have walked this journey for about 2 months or 3 months. Some have been with us for over 8 years on the MOOT. Others have just joined, but just know that what you submitted, none of the SEHAD staff reviewed. Their role was to receive, I don't know via which email. Do we have a MOOT's email? Or someone's email, and forwarding to the judges. So it's just fair that we recognize the efforts of our judges for first of all being here with us the whole day, listening to all the beautiful speeches, looking at whoever wanted to cry but had to move on, and also giving us the sweet guidance. I hope that people have taken in the guidance, and I will kindly request to award His Worship Timothy Lumunye with a certificate for participating in this MOOT, but also being our judge. And the judges' awards is not in any order of this was the best judge, no. It is all the same information there. So, Your Worship, we really appreciate you. Thank you. The ones who didn't clap are the ones who didn't take your guidance. And then Her Worship Baluka Nora for really walking this journey with us. Thank you so much for the guidance. Thank you for standing with us the whole day. And thank you for accepting to share knowledge with our students. His Worship Busura Ivan. We continue to appreciate you, our dear judges, for the day. Thank you so much for sharing knowledge with us. We really appreciate. Thank you. Her Worship Wemesa Caroline. You also need to thank the SEHAD team. Have you noticed that there was gender balance? You haven't. Have you noticed? I hadn't seen it until now. But other tasks, Vanangi. What a smile. All right, thank you so much. Thank you, Your Worship. Her Worship Esther Joyce. Also work hard to be recognized as judges, eh? Yes. Thank you so much. Thank you. And His Worship, Joel Wegoe. So are we tired of clapping? And can you say in your heart that we look forward to taking over from you? Like you can be this side. So I'm going to appreciate you once again, all our dear judges, for the day. We really want to thank you so much. I already indicated that we will not have them tomorrow. We'll have judges from the Constitutional Court, Supreme Court, and High Court who will constitute a panel. So since we'll not have them tomorrow, and they did the marking and rewarding of the best memorials, I am going to request all of them to come and hand over the awards to the best memorials. So our dear judges for that day, kindly join me to celebrate our students. So our dear judges, we had the best memorials from Cavendish University. So we request the representation of Cavendish to kindly come and receive your award from the judges. Hey, we have one person from Cavendish. Okay. It's also your time to take a photo with the judges. You're not going to have it again. And feel free, even if you're 10, to join and take this photo. So we can request the judges that we allow the students. We can also extend the other side and feel free and receive our award with a photo that we can go back and pin at our office, our universities. Okay, all those hand claps are for Cavendish. Congratulations to you. So where are the smiles? So we can allow the students to take the photo with the judges. Also, we want the best smiles, Danang. So thank you so much. It takes an effort to read pleadings and also get sense out of the pleadings. So we want to appreciate you, students from Cavendish. And the second best memorial was coming in from Uganda Pentecostal University, Kampala campus. So Kampala campus, Uganda Pentecostal, are we here? You see the energy that Cavendish is bringing in. Oh, we celebrate with you. Thank you so much. Please take your time and take a photo. We can all fit here. We can all fit. Camera person, are we good? Are you sure I got all of us, including me? Please take the moment when they're smiling. And let the students now, the ones who mooted, take a photo with the judges. And it is just fair, our dear judges, that you kindly allow us some more minutes to have other universities take photos with you. So first we are going to take every university, then we'll do a group photo. Is that acceptable? So shall we have the next university available to kindly take photos with our judges? It's very okay. The faster you do it, the better, because the photo is for you. It's a moment for you as a university. So the universities that have not taken, kindly get here and take photos with the judges. Are you? Please hurry. Let's take one campus at a moment so that people are able to, sorry, I should have helped. So that people are able to take photos. Are you? If I'm really haram, please move. Also, we are allowing our judges to sit because then we are going to take a group photo. The students, eh? Okay, could the students just stand behind? I hope the next university is ready as these ones take. Please move like ladies. Ladies don't walk like snails. They move like real ladies. Okay, so this campus is which one now? So which campus is this? Females campus first, okay. We had 2 representation. Okay. Camera person, can... Pardon? For the judges. Okay, can I have some energetic men and women? Energetic, we are advised to change the judges to sit rather down. So I really wanted to pull the chairs for them. For better photos, eh? Thank you. So our dear judges, we are going to request you to kindly utilize the chairs down. And camera person, where do the students go? Behind the, okay, all right. So dear students, kindly just come and stand behind the judges, just where I am. Please move like ladies. If you're going to move in this world like your snails, that's how you will be forever. Sorry, I'm an activist, so I say the truth. And nothing but the truth. Ruth, one goes off. Okay, the smiles are from Kampala campus. IU. Female campus, sorry. As Kaboja, is it female campus Kaboja? As another campus prepares. Thank you so much. Another campus. Camera person, if I'm fast, you let me know. But I need to release the judges. As the other campus gets ready, please make sure your MOOT coordinator gets a link for the photos and you download your photos. So where are the smiles? Next campus, please get ready. You know, I need to keep these things for your children. Otherwise, they'll say, Daddy, wasoma. Daga ichfananyi. Next university. Thank you, camera person. Next university, as the other prepares. Please don't go out. We are going to take a photo, all of us. Hey, where are the smiles? The ladies are telling me, why didn't you warn us to put makeup? And I'm like, I've worn mine since morning. What happened to yours? Next university, please. As the next one prepares. Wangwe negative nga tezina gwamu. Hello, where are the smiles also? Hey, when the first team was taking a photo, but because they were ladies, there's a side that was clapping. Nah, mama, this one. Is it because it's not gender balanced? Okay, next university. Next university, please. Please be sure that you get your photos through your MOOT coordinators. Sweetheart, over you extend to this side and balance. Camera person, are we good? Thank you. Next university. Camera person, please bring us back when we are in this same color. Don't bring us when we are yellow. So do we have any other university pending? One more after this? Nice, okay. See the smiles, right? You have to clap for these. Please clap. Okay, and the last university. Is that the last one? Okay. So we have partners that have joined us in the room to just see how you're mooting. Can I request a representation of the partners in the house, who are also our funders apparently, to come and take photos with the judges, please? Our partners who joined us and supported this, please come and take a shot. We have representation from RHU here and Sonke. The money members, woo! Yes. Thank you for supporting us. All right, thank you so much. So because we had 11 universities, I am going to request the MOOT coordinators to kindly come and take a photo with the judges. As the clerks prepare and the social media influencers who have made sure that we are actually up in the cloud. So MOOT coordinators first, clerks please prepare, then the journalists, social media influencers, you also prepare. You know these people never want photos. Now they're saying, Katia tulabia atia. Coordinators please, where are we? From the different universities. Those hand claps are from your team members. If you don't feel them, you know they are not appreciative of you. Let's appreciate our supervisors, our lecturers, our MOOT coordinators. Please clap so that they smile. Our court clerks, get ready. We should be here by now. Our court clerks. Camera person, not here. A negative, tesora kugwa mkusawen. MOOT coordinators, please step forward. You guys, they said they will not smile until you clap for them. Our court clerks for the day. Court clerks, please. So the guys who have made sure that we are visible, please move. The guys who made sure that we are visible somewhere, move. Come and you take a photo with us. Fatha, lead your team. Fatha, please lead your team. I know we're about 10, so you better move. Fatha, please move, and I would request the SEHAD staff to move last. Who has not taken a photo? So our social media influencers. Okay. Thank you. And then shall we have the SEHAD staff last? Sorry, camera people, we can't take your photos. Because when we say we're taking a photo, then who will take it? Thank you so much for making sure that what we are discussing here is out there. You see, the smiles are different, eh? Even when you didn't clap. So SEHAD staff, please move faster. Our judges are tired and we need to release them. SEHAD staff, safe. Safe, move. Frank, Fred, Tracy, who else? When you see them in black shirts, you tell them, say, Baitagwe. Hey, Bozi. Oh, God. Okay, we are in black, but now we have to smile and show them the real smile. Camera person, we really wanted to do a group photo with all universities. We take note of the fact that it's usually done on the second day and not the first day. I don't know how to organize ourselves. So usually on the second day we take a photo on the stairs towards the pool. We know where it is. Shall we request our judges to kindly move with us and we take that photo? If you see last year, we only had the photo for the second day. And people keep asking us, so our dear judges, are you in position to move with us to the stairs? And our dear students, it's a group photo for us all. Our luggage, property is safe. I'm sure there are people who don't want to take photos here, the social media influencers. Banange tugende tukube ekifaananyi. Betumaliriza tukomewo wano for the last, say, there's no session after, but we want the first runner up and second runner up, right? The two universities to stay behind. And those ones who slept here have to eat. So students and coordinators, I don't know who slept here, but I know some people slept here. So whoever slept here, you please come back to be guided. But in the meantime, the judges cannot be moving, and for us, we are not moving. So let's get to the stairs and then take our photo. Then we'll request those ones who slept here to come back, plus I think the MOOTers and the coordinators. Thank you.